Hi everyone, this is Daniel Chesmore again. We're here on part 3 of our final review of property law for the bar exam. So really quick before we delve in, California HOA rules and bylaws. Remember anything that infringes on an important interest, look for that in your facts. Look at whether or not it affects others within the HOA rules when we're doing our analysis, whether the court will strike down that rule or uphold it, like the swimming pool example and the fence that we talked about. We want to look at whether or not it does actually affect others within an HOA. If it does not affect others, then it'll probably be struck down. If it affects others, it might be upheld. And no important interest that affects others, yes, it will be upheld. So in the case of affecting others, like their property rights, you can make that argument on both sides, depending on your facts. So we've got a lot to talk about here. We'll talk about leaseholds in this topic, but just generally here talking about the obligations to a landlord. If a tenant holds over and continues to pay rent, and the landlord cashes in those tenant checks without remark, then it's treated like a new lease. And it's the best course of a landlord is generally to refuse all rental payments and file a summary proceeding to evict the tenant. There's no self-help to recover. Courts hate wasted space. So those public interest factors that we always keep in mind. So if a tenant surrenders before the end of the lease, then if the landlord rejects that surrender and fails to mitigate, the tenant is not obligated to pay damages. Look for issues of fact on any sort of mitigation, a reasonable effort. And remember that a landlord can accept the payment or can collect any back rent or damages owed by the breach, loss of rent for length of time to retake the property. So the landlord can also reject and hold the tenant to the lease, can collect on back rent owed and future rent owed under lease, minus amount of rent able to collect via mitigation. So we'll also talk about commercial leases. I guess we can talk about, sorry, navigating this chart. When a tenant assigns a sublease, I think before we start on this topic of tenants and assignment and subleases and commercial rents, I want to talk about leaseholds before we delve in. So leaseholds, they can either be residential or they can be commercial. There are 4 categories of leaseholds. We've got, starting with periodic tenancy. This is like what we know as a month to month or year to year. These periodic tenancies renew automatically at each specified period. It could be a month or a year, unless the landlord and tenant decide to end the period or the landlord-tenant relationship. We look for notice, depending on the state set time, before terminating, and it's not terminated automatically at death. So that's our first category. Another one is a term of years. So here, death of either party does not automatically terminate a term of years. It runs its course. It exists if language of lease states will last for a specified period of time, maybe 3 years, 6 years, 1 year, 100 days, 1,000 years, for that length of time, unless a tenant is breaching the material term of a lease. The landlord may not evict a term of years tenant before the end of term. Third, we have tenancy at will. We have, in this case, it's created when a lease states either party may terminate lease without notice. The death of the tenant or landlord terminates at will, and death of either party does not automatically terminate a term of years. It runs its course. As we talked about before, that's distinguished from tenancy at will, where either party may terminate without notice. So it's an at-will lease. And last, tenancy at sufferance. It's created when a tenant was formerly in rightful possession, but is now in wrongful possession, like a holdover tenant, and refuses to leave, legally categorized as tenant at sufferance, not a trespasser for purpose of eviction law. Now, very important, within leaseholds, we want to look at the statute of frauds. Remember, if it's over a year, under a general rule on contracts, it must be in writing. It's unenforceable if not in writing. So always look for if there's a writing in your fact pattern or on the multiple choice. If it's less than a year, then we have that exception where it can actually be an oral contract or it can be in writing. Month to month or at will is outside the scope of the statute of frauds. And once a license permission is revoked, a trespasser can use self-help to revoke, such as changing locks. We'll talk about that later. And so here, an owner must initiate summary proceedings instead of just changing locks, as we'll later discuss. So within leaseholds, we have in leasehold agreements that the landlord and the tenant make written oral promises regarding duties owed to one another. Courts impose duties on landlord and tenants as a matter of law. There's a landlord duty to tenant. Landlord's failure to deliver premises is a material breach. And if a tenant the tenant will get damages in such a scenario where the landlord might fail to actually deliver the premises, deliver the keys, deliver access to the structures for the enjoyment of the tenant. And there's this legal duty to deliver this actual possession at the beginning of the leasehold. And the landlord must file summary proceedings to actually evict. We look for any sort of damage to premises in that relationship, and whether there is damage, that's a tenant's duty. Also within the tenant's duty to the landlord, we want to look at, in addition to no damage to the premises, the tenant is not to violate the reasonable rules in the lease, like paying rent on time, not being too loud for other neighbors, following the local law, endless examples, and allow the landlord reasonable access to inspect the property and conduct repair. Here we have good faith rent tied to a commercial lease. This is also known as our business profit leases. Look for any sort of minimum rent provision if it's a part commercial lease. If it's an entire commercial lease that's based on some sort of reference to the lease is contingent upon the performance of the commercial entity, look for good faith for the entire lease. If not, look for some sort of breach and then subsequent damages. Look for some sort of look at whether or not there's a substantial minimum in a commercial lease. Substantially more than fair market value, question of fact, no duty to operate. So if you have a commercial lease where your lease is actually tied to profits or to revenues, if you have a substantial minimum built in the contract, you may not necessarily have a duty to operate that commercial entity. So within leaseholds, we also get in this topic of when a landlord or tenant dies. So here, a number of related topics. When tenants assign or sublease their interests, if the lease is silent, tenant has a common law right to assign/sublease. So if that's outside the scope of the actual terms of the lease, then it's actually acceptable since it's not specified in that lease agreement. Unless there's an absolute prohibition from assignment, subleasing, court will enforce the prohibition. Look for transfer of some sort of entire interest in the assignment. The landlord and the tenant. So in this diagram, we have the landlord suing the tenant, but can sue for summary proceedings against an assignee who's maybe a holdover tenant. It can also sue damages against the assignee in this case. Rent acceleration clause, enforceable if reasonable estimate of actual damages landlord is likely to suffer as a result of breach. Liquidated damages, provisions in a lease or breaches. If tenant abandons property, rent comes due. we will also talk about sublease. So we talked about assignment, now talking about sublease. If the sublease is less than the entire interest, then we look at this diagram where the landlord can actually sue the tenant for damages, but the summary proceedings can be launched against the subleasee, who might be a holdover tenant. Whatever legal rights survive their deaths pass to beneficiaries/heirs when a landlord or tenant dies. When landlord consents to assignment or sublease, sublet is required. And then commercial lease, we'll talk about again. Commercial lease, look for whether or not in a commercial lease for these buzzwords, and we want to use these words to be precise on a bar exam, that the exact words are commercially reasonable. Landlord can only withhold if it is commercially reasonable. Look at the position of the assignee. Look at suitability. The financial position of the assignee. Look for suitability of property for proposed assignee and their business. And look for any sort of need for alteration of premises, legality, proposed use, nature of occupancy, withholding consent for assignment, sublet. These are examples of what are not considered commercially reasonable. Majority rule is that there is no reasonableness rule. We look for legality. And here in the residential home, it can be arbitrary or unreasonable. In a commercial lease, but you can't necessarily have an illegal discrimination because, as we talked about, we can't force the court to otherwise violate the due process clause or the equal protection clause. I think we talked about this, but just to put in context, if the tenant holds over and continues to pay rent and landlord cashes tenant's check without remark, it's treated like a new lease. Best course is to refuse all rental payments and file a summary proceeding to evict the tenant. No self-help to recover. Courts hate wasted space. We talked about this, where a tenant might surrender at the end of the lease. The landlord surrenders, fails to mitigate, tenant not obligated to pay damages, issues a fact on mitigation, look for reasonable effort. And the landlord can accept or collect any back rent owed and damages caused by breach. Look for loss of rent for length of time to retake property. Landlord must mitigate reasonable effort to relet premises. Effort to mitigate. We'll look for some sort of facts that show if landlord can reject and hold tenant to lease, can collect on back rent owed, future rent owed, and release minus amount of rent able to collect via mitigation. One should not be able to sit on their losses. Look for that mitigation within your facts. Now, a frequent issue that's tested is that you might have a scenario where a contract is created and it creates a license or lease in the context of a mall or a college or apartments, dorms. And we have to distinguish a license versus a lease. And we want to argue both sides if this is an essay. If it's a lease or license, if there's no statute and statutory answers to the question of in particular agreement is a license or a lease, court will decide if owner transferred the exclusive possession of defined space, and whether or not if that exists, then we'll look more in terms of finding a lease exists from the owner. If we have control of the space not entirely transferred, or possession of the space is not exclusive to tenant, court more likely to find that the contract created a license. And the focus is on how much control the owner retained over the over the issue, the property in question. So within the leasehold, we've got other forms of living spaces, such as migrant farm workers, who are more likely to be found as licensees and not tenants. In the case of licensees, you're allowed to use self-help to remove the licenses. When a contract includes living space but found not to be a lease, courts may apply contract principles to grant rights to license holder, but the court will not enforce contract provisions if they are in violation. Like the constitutional violations that we talked about, And the court may also revise the contract if it finds them unconscionable. So argue public policy here, PP, that we talked about, that we don't want to, the court should not be able to enforce any illegal discrimination under the Constitution, since the court is a state actor, even though all of this relates typically to private actors, with the exception of maybe perhaps a public university in the context of dorms. Yes, so the court may revise the contract if it finds it unreasonable. We look for facts like unequal bargaining power, and we look for unfair terms. And a challenge for these unfair terms under legality, as we've been talking about. Absent contract provisions for terminated, fired employees where employment includes living space, we need to also look for reasonable time as a matter of public policy to allow the former licensee to find shelter after being terminated. No self-help is allowed in such contexts and must use summary proceeding instead. And so this is a public policy when it comes to determining whether or not housing provided through the context of employment is more likely to be under the scope of a lease or a license. Now, implied covenant of quiet enjoyment. In commercial and residential leases, landlord not to disturb quiet enjoyment. So that is a duty of a landlord. And the implied warranty of habitability. It applies to residential only, since you don't necessarily need things that we use in the residential context in the commercial context. And so that is a difference. You might see that in multiple choice. So remember, quiet enjoyment applies to both commercial and residential, but warrantability, warranty of habitability, we think mostly in terms of how it applies to residential contexts. So if it complies with state, local codes, and general community standards, those are the facts we're looking for: suitability of occupancy, usually invoked as a claim or defense. Tenant must give landlord notice of probable and reasonable opportunity to fix. When landlord is in breach of habitability, tenant can have a variety of options. They can terminate the lease and move out. They can remain and withhold until the dispute is resolved. They can make repairs and deduct costs from rent, or they can sue for an injunction, rent abatement, and/or compensatory damages. Courts may possibly also allow punitive damages if the landlord was intentional and malicious in landlord's conduct. And now we'll move on. So that is, in a nutshell, everything we need for the bar when we're talking about leaseholds, rent acceleration, commercial reasonableness, and commercial leases. We want to look at whether or not we've got substantial minimums in a commercial contract, and if we do have a substantial minimum, then there is no required duty to operate a business. Commercial leases, yes, commercial reasonability. We talked about at death, at death, very generally, the legal rights survive their deaths. They are then transferred to the beneficiary / the heirs, as we'll discuss in the context of wills and trusts later on. And yeah, and feel free to comment if you have any questions on leaseholds, and I'll try to respond as soon as I can. So moving on to rules and decisions made by condos, associations, and HOAs. I realize that, that first heading really applies to condo associations. Look for some sort of substantial and process rule, declaration of a, this is actually, these rules they are substantive and procedural rules. So declaration of a condominium, excuse me as I get a drink of water. Declaration of condominium or declaration of HOA. Look for they're viewed very broadly and in favor of exercise of power. Rules and bylaws are enforceable if they're reasonable, and the court will balance the importance of rule rules objectively against importance of the interests infringed upon. There will generally be more suspicion if there is some sort of important civil liberty interest or significant burden on important interest. And there's no effect on others than the tenant wins and the rules are struck down. Rules will usually be upheld if they affect others, such as not putting trash on your lawn and keeping your space clean and raking your leaves. That does affect others because that trash and those leaves can blow onto other properties. Courts are more likely to uphold that. But if it's something that you do in private, like if it's a gated fence and a pool fence, which the HOA rules or the condo association rules might say that you're not allowed to have a fence around your pool. But if no one can really see it because you have a reasonable expectation of privacy around your home, as denoted by the fence, then courts are more likely to strike that down since it really doesn't affect others. What you do in your backyard, it really depends on the context. Maybe look at the facts to the height of the fence to make that argument. On an essay, look to whether or not, one, the first question we'll ask, and you can put this on a heading, is that has a covenant been created? And examples of covenant, as we talked about, like implied reciprocal negative servitude or an equitable servitude or a real covenant. Look at enforceable or unenforceable as a matter of public policy. If it's unenforceable as public policy, then no further inquiry. But we most likely in a bar exam want to continue arguing in the alternative and explore the rest of the questions. So the second part of the question would be, or the third part, beyond creation of covenant and public policy inquiries. We want to look at whether the covenant was terminated or modified or restricted. And we also want to look at the remedy, because that's what we later talk about in constitutional law, is that for standing, we want some sort of redressability or some sort of remedy that the court can provide. Without a remedy, why should the court really hear the case? The courts, after all, of course, are there to offer some sort of remedy to, or potential remedy, and to adjudicate that issue before two or more parties. So beyond termination of covenant, we talked about the remedy, and within the remedy on that last part, it can be maybe injunctive relief or it can be damages for the violation. We look at we assume creation enforceability not terminated. And remember that non-charity conditional restraint on alienation. We'll talk about that again since it is an important concept and I have a feeling that it actually might come up on the bar. I didn't see it in a lot of the most recent examples from the California or the Hawaii bar exams, so they may actually come up. So unreasonable conditional restraint will be considered unreasonable if it makes sale of property so difficult that as a practical manner operates as a total restraint on alienation. That's an unreasonable conditional restraint because we think about we don't want to alienate fee simple. Also look at whether or not there's some sort of ambiguously worded covenant. Courts will favor free use of land. Restrictive covenants are generally disfavored. Now, where there's any ambiguity, substantial doubt on meeting, the real covenant will be read reasonably in favor of free use of land. We also look to grantor consent clause, generally unenforceable, trying to create a co-op through covenant, for example. Covenant and deed statute stating that the grantee must get grantor's permission before alienating the property. E.g., for example, no right to buy, sell without grantor's written consent. Freedom to alienate is essential to grant of title from the I think an example of this where it might be permissible is low-income housing owned by the state. San Francisco has an option, I believe, where low-income homeowners can purchase property, but they can't necessarily sell it on the free market. They have to go through specific clauses, which they agree. But usually these are generally unenforceable, and void. But we also want to balance that against the freedom to alienate, which is an essential grant of title. Rights of first refusal, they're enforceable if they're reasonable. It's a question of fact. within rights of first refusal, such as you have to go and you have to at least give the option to sell or to lease to some entity, usually in the context of selling a property. It's enforceable if it's reasonable, question of fact. There's a two-part test to determine reasonableness. This will come up on a multiple choice or an essay, I'm pretty sure. Covenant in deed that states that if a grantor decides to sell, he must first give a particular party, often a condo association, right to purchase the property at market value. Fact finder considers whether reason for exercising right of first refusal was rationally related to the purpose of association. And we look to bylaws, whether exercise of right was fair and non-discriminatory. And we look for breach of some sort of fiduciary duty and, of course, that discrimination piece. So affordable housing restrictions, generally enforceable. Covenant stating property may only be sold or leased before market to low-income person. I just talked about that example of San Francisco, that those are generally enforceable. We can also argue public policy interests. In my own personal opinion, I won't share this that often, I really do wish that we could have a Singapore-style mode of homeownership that would allow over 90% of the population to have homeownership subsidized by the government. It would make for practical use of reducing poverty and creating opportunities for future generations of Americans, but we'll see. For now, we'll continue living in our finite world where land is a finite resource, unfortunately. Restrictions in leasing, generally enforceable. Absolute limits on transfer of a lease are generally valid and enforceable. Covenant prohibiting tenant from subletting or signing a lease is likely to be enforced unless there's some sort of a statute prohibition. That's a restriction in leasing, generally enforceable, such as not transferring your lease. Private landlord might say that tenants are not able to transfer their leases because the developer might want very high credit scores and wants to be able to control who lives in that area. And courts will generally find those enforceable. Those prohibitions on transferring that lease, unless there's some sort of statutory prohibition where under the 10th Amendment, states and state legislators could actually step in and regulate that. It depends. I'm not aware of any prohibitions in either California or Hawaii. Unreasonable covenant, unenforceable usually in both topic and duration. In regards of topic, covenant allowing an HOA or condo association control or ability to veto renovations have little or no effect on neighbors. So again, just going back onto our general rule where if we do have some sort of effect on others, it's usually upheld. But if we don't have the rule affecting others, then it's generally struck down. So we want to, there's no point in remember overlapping with that restriction on alienability of fee simple. We want to look at whether or not that rule would actually protect the interests of others or have some sort of impact on others. And if it does, then it's going to be upheld. If it does not, like that ridiculous example of what you can do in your own home that's sheltered and fenced off, like having a backyard and a pool fence to protect against toddlers falling in, which is a real concern for parents, then that will generally be struck down. In Hawaii, these rules are very essential since a large segment of the population are members of HOAs or condo associations. So again, if it's too arbitrary or controlling, then it's most likely going to be an unreasonable covenant, unenforceable, and we look for a covenant that is longer than necessary to achieve its original purpose as unreasonable. So we talked about two-part for reasonableness. Again, for rights of first refusal, it's a question of fact. I want to talk about this again since I think it might come up on an essay real quick. That two-part test for reasonableness, remember again, and I'll say it a second time only because I do think it might be on the bar exam. A fact finder considers 1. Whether reason for exercising right of first refusal was rationally related, kind of relates to our constitutional law terms in regards to applicable levels of scrutiny, to the purposes of association, and we look to the bylaws in that case for the rationally related to the purposes, and we also look at whether exercise of right was fair and non-discriminatory, look for breach of fiduciary duty and discrimination in our facts. Anti-competition, aka non-compete covenants, they're only enforceable if reasonable, and this is also a question of fact. And within the definition of reasonable, we want to look at some sort of economic justifications that are needed. Like, for example, this is bad for the economy, some public interest factors, usually about restraint on alienation, reasonably limited in time, in space, or in product line. Like maybe you might have the classic fact pattern of a mini mall that already has a nail salon, and we don't want a second nail salon since that might disrupt the integrity of that existing nail salon. So it might be reasonable because that's such a narrow scope within a small little mini mall. But if it's an absolute prohibition where you might have someone who owns an entire island, like the entire island of Lanai, to only have it so that there are no nail salons allowed except for one owned by the owner of Lanai, then that might hopefully be struck down for public interest since it is overly restrictive. And I would not find that reasonable, but you can argue it both ways. Prevent antitrust, monopoly in a food desert as public policy interests, and serves broader public interests of facilitating orderly and harmonious development for commercial use, not having to discount stores in the same mini mall or nail salons as we talked about, and commercially reasonable within the context of the developer's plan. So coffee shops can only have coffee shops in the mall versus in the city, the entire city or entire island, in the example of Lanai. So that is what we want to talk about in the context of condo associations, HOAs, different rules, example of the fence, or maybe in a commercial context. All relates to our previous topic on covenants, which you can see in depth in our second video of this 3-part series. So here, also want to talk about, we talked about restrictions on leasing, generally enforceable. Again, for that interest, landlords should be able to assess someone with a high credit score, and just because a tenant wants to leave and wants to find any sort of assignee and wants to sign that lease, or sublet that space, then if the original lease between the tenant and the landlord prohibits that, then that will be upheld regardless of a legal challenge brought by the tenant. We also want to look at covenants against the broader public interests, which are unenforceable. They are unenforceable if contrary to stated public policy and social harms flow from enforcing covenant outweighs the benefits. So this is our balancing test. We want to look at social harms outweighing the benefits. And we want to look at the source of public policy, which can be federal, state, legislative, or judicial decisions. Food desert, we talked about, as a concern for elderly in the Davidson case, or rehabilitation of inner cities, for example. Now, we talked about this multiple times. I think it will come up since it is such a hot topic. Within a covenant, discrimination against people with disabilities is usually unenforceable, and for great reason. We're not going to enforce the covenant if it violates public policy to prohibit discrimination against people with disabilities. But also that public policy overlaps with what we'll explore in constitutional legal context, where if the courts were to actually uphold discrimination against those with disabilities protected under the ADA, then that would actually make the state actor, or in this case, the judge or the court, violate the Constitution and violate arguments made in due process and the Equal Protection Clause. And we'll talk about that in the context of animus, in the context of equal protection in our subsequent videos, as we plan on covering constitutional law, both 1 and 2, for a standard 1-year legal course. In the next video, I'll try to do that under 2 hours. I think we're already almost 2 hours for our our video series, but we're almost there. Moving forward, we want to look at some sort of common interest. Again, within the common interest, which if it violates public policy, and in this case, if it's enforceable in term or in some sort of, or in various communities that we'll explore. We want to look at micromanagement examples, weight against liberty, and we want to balance discrimination versus individual privacy rights. Now, courts will apply that reasonable test or the rules or the bylaws. And courts will balance, generally, courts will balance the importance of rules objective against the importance of interests that are infringed. Public policy curtails civil liberty or significant important interests. Remember, so the objective of the rule and the public policy interests as a balancing test, and also whether or not the harm is outweighs the benefit. Within enforcing a covenant. So here, amending covenant terms, reasonable test. It's a question of fact. There's a lot of leeway to amend after the rule, and we'll talk very quickly about different types of common interest communities, otherwise known as CICs, common interest communities. My favorite example is a co-op, but also other examples of community land trusts and HOA condo associations. But in my favorite example of co-ops, over here we have that a co-op, an example of a classic co-op is where an entire building is owned by a single nonprofit corporation. Once the applicant is approved, they must buy in by purchasing shares in the nonprofit corporation and leasing the unit from the corporation. So we're all shareholders in the example of a co-op, and the corporation chooses who moves in. So again, within that, but however, we want to avoid racial discrimination, sexual orientation discrimination, gender discrimination, religious discrimination, disabilities discrimination, etc. Anything that might be found to violate public policy or perhaps to force the judiciary to violate the Constitution. Now, the corporation is usually financed by a single mortgage loan obtained by the corporation. Monthly rent covers the mortgage and upkeep and the management. Owners must make up the difference to avoid foreclosure, and it can be discriminatory, but this can be discriminatory since other members are bound here, and but in this case, it's not really a covenant because each lease bound to contract and lease. Cooperation does not run with the land. So in this case, a co-op, they can actually be a little bit more discriminatory than other types of covenants, like that example of an IRNS, of a revocable IRNS, reciprocal negative servitude. Then that is a covenant. It runs with the land as a servitude. But here, this is actually by contract. So we want to distinguish whether or not is this a contract or is this perhaps a covenant. We'll actually look at that really quickly. I'm sorry, it was implied reciprocal negative servitude. That's right. I always remember it as an IRNS. So that example that we talked about in video 2 of that condo element, enforceable as a covenant, but distinguished versus a contract. So that question of fact may come up on an essay or may come up on the strongest argument question on a multiple choice. So look for that. HOA condo associations, those are classic examples of covenant that runs with lands, like the IRNS example we just talked about, implied reciprocal negative servitude. Covenant runs with the land, bound by promise from the prior owner, which was made. These are usually fee simple from the open market. There's no control over the neighbors, and you can collect dues or fees for common areas. It can enforce covenants, and you can promulgate those rules. The lot owners are automatically members of the association with voting powers, and they're created when a developer files the declaration, the deed, or it could be the declaration, or it could be any sort of formalized writing that has legal rights assigned before the sale of the first lot. Lot owners borrow money to purchase their own lots or units separately. All lot unit owners co-own common areas as tenancies in common. So we'll talk about that. Now, tying that principle back to our last video and this chart that we have here within implied reciprocal negative servitude, we look for, remember, within our requirements here, our five, our requirements here are, we want to look for some sort of deed or recorded deed or any sort of equivalent that's distinguished from a real covenant, which has these other issues, or an equitable servitude. Remember, IRNS, I like to think about it as a classic developer model. Real covenants have more requirements. There's a touch and concern and privity, in addition to the first elements that kind of overlap with our written negative servitudes, where we have writing intent and notice. I like to remember it as WIN, plus touch and concern and privity for real covenants. IRNS has these other elements distinguished from an equitable servitude, where we look at more of a promise, where equitable servitude is pretty much a real covenant, except there isn't that privity. So if we have WIN, writing, intent, notice, and touch and concern, but we don't have that privity, horizontal, vertical, like the straw man situation, then we're more likely to have an equitable servitude. So a lot of these overlap, and we want to argue one or the other. They can be one or more. Of course, if you are, in this case, if you are, remember, if you are a real covenant, then you can also be an equitable servitude. Just look at the facts. So that's our example of HOA condo associations. They own the co-spaces, the common areas as tenancies in common. Distinguish against a co-op where it's a corporation and they're shareholders, and the corporation is not really tied, it doesn't run with the land, so it might violate some other laws, but not laws that we'll discuss in property. Community land trusts, very common in the state of Hawaii. They're nonprofits, allow lower income individuals to purchase real estate. The trust buys or holds title and leases a building, but not the land, for a long period of time. Very common in Hawaii to have 99-year term leases, where you can own the structure, but you only have a lease on the land. They're usually for low-income purchasers below market, and you can't really sublease at market. You may sell or sublease at purchase price, adjusted for inflation, but these are enforced usually as contracts if the original promisor, promisor is present in dispute. And I think that's it. That is it. Yes, we covered all of this. Wow, we covered a lot here. We covered the rules and decisions by condo associations and HOAs, whether those can be upheld, questions we look for if it applies to a covenant. Usually we want to see if it's covenant like what we talked about in our past video, or in that example of IRNS, and how it relates to HOAs, condo associations, or we want to argue an alternative that it might be a corporation without any running with the land requirement to really be a servitude and really falls in line with contract law. Great essay topics, since a lot of this overlaps with constitutional law, overlaps with contracts, other legal topics that we won't need to focus on for the bar. But a really good way to piece together very different concepts and how they come together in the context of property. So remember, on an essay, just quick review. If this is on an essay, we want to look at first if there's a covenant, to look if there's a real covenant, look if there's an equitable servitude or IR and S. We want to look if the covenant's terminated, modified, restricted, look at the remedy, damages or injunctive relief, and there you go. And public policy, of course. We always want to argue public policy in our essays. So moving on here, really quick, I want to just talk about life tenants before we do an example of our conveyances. Life tenants, holder of a life, estate, or term of years tenant has a duty to future interest not to injure the property, must keep property in sufficient repair to prevent decay. No action on fundamental or destruction that fundamentally alters a condition of the property, and a landlord can later bring a waste claim. And waste claims for a landlord from a tenant who commits waste can be one of for 3 different types of waste. I like to remember this as VPA, or you can remember it as VAP for vape. During, possession, or after. Voluntary, permissive, deliberate act. Look for some sort of voluntary act on the tenant. But if it's not some sort of overt voluntary act, it might be permissive. It might be where it was a failure to exercise ordinary care of a prudent person, distinguished from ordinary wear and tear, which is not waste. And ameliorating, which changes property in a way that increases value, but fundamentally changes character on condition of property. So in the case of where you might get, where a tenant might rent a house, but decides to convert it into a donut shop without permission, but that donut shop is actually worth a lot of money because, let's say in our hypothetical, there's no other donut shop in the city, and so this one becomes a very prosperous donut shop. However, in that case, that example, it would still be waste. It would be considered ameliorating. So even though it raises the property value, it doesn't necessarily mean it precludes the landlord from bringing a claim against the tenant. And so the landlord may answer a claim for, or I'm sorry, a defendant tenant may answer claim for ameliorating waste by arguing complete and permanent change of surrounding conditions which have deprived the property of its values and usefulness as previously used. And remember this rule, there is no punishment for marrying. Court's likely to find that there's a fee interest, and they like the fee interest. So in that case, if you, we mention that only because if you might get married and you might fundamentally alter the property by adding on a room or some sort of in-law that increases value, then look for those facts and public interests. Weighed against the landlord's claims to have rights over the land versus the breach of the lease. And within the breach of lease, there are several options here that we can talk about. Different possibilities where you can have summary proceedings to actually evict the tenant, or you could have damages to bring back that property to its original form. We mentioned that marrying, courts, that we don't want punishment for marrying because courts like fee interest within the context of public policy. So we've covered servitudes, we've covered a lot. We've covered HOA, condo associations, and other sorts of public policy interests and different terms of leases and commercial leases, residential leases, and we tied all of that back to our previous lesson on servitudes and different forms of covenants, also different forms of easements. We can review that again very quickly just to show a high level, but here at this time I'll just do a high level view in case you wanted to just pause and take note of our chart here. I'll go really slow so that instead of having to rewind my whole video and hear me speak painfully for so long, you can just pause the video and look at my chart. And you can just see there. It's kind of hard to get the full view, but there you go. Now, before we wrap up, I want to just do a quick review. I've got flashcards here of pretty much all of our property topics, which I'll read very quickly. Before we do that, we'll just talk about conveyances, and we'll do that for the next hour. So this chart is very useful if you want to pause this. We've got different types of present estates. We have fee simple absolute. We look, for example, like 2A or 2A and her heirs. The duration of this is forever. There is no future interest or grantor. It's up to the fee simple absolute possessor, and there's no future interest in a third party. So fee simple absolute. That's the best one where you can do whatever you want to the property. Well, not whatever you want. Follow state and local laws, of course. Fee simple determinable. 2A for as long as, until, while, during. So 2A for so long as he follows all state laws, or 2A until he gets married. But courts don't usually like that. It depends. You can argue both ways. 2A while he goes to law school, 2A during medical school. As long as the condition is met, then automatically to grantor, but there is a possibility of reverter if that condition is no longer met. And the future interest in the third party is an executory interest. So fee simple determinable, where we can restrict fee simple absolute, distinguished from fee simple absolute. Fee simple fee simple subject to condition subsequent. Look for language such as 2A, but if, or so 2A during law school, but if A drops out of law school or does not, or 2A as so long as he finishes law school, but if A does not finish law school, then 2B. In that example, until happening of that named event of finishing law school, there's a re-entry by the grantor, so right of entry. It could be 2A during law school, but 2A provided that A goes to law school. If A doesn't go to law school, then the original grantor can have a right of entry. That is also related to fee simple determinable, where it can be 4A during law school, but if A doesn't go to law school, then possibility of reverter, or it could be 2A provided that A goes to law school. There can also be some sort of executory interest in a third party, where the grantor might pass away and it might go to the estate, and that executory interest would go to the estate of A. Or not, I'm sorry, the grantor. There is fee simple subject to executory interest, 2A for so long as A goes to law school, and if not, then to B. Or 2A, but if A fails to go to law school, to B. As long as condition is met, then to third party, until happening of event for the duration. There is both a possibility of reverter and a right of entry, where this kind of relates to both fee simple determinable and fee simple subject to condition subsequent. And there could be an executory interest depending on the facts, where the grantor might pass away and that interest goes to the estate. Life estates, 2A for life, for the life of B, for life, then to B, for life, but if A does not go to law school, then to B, until the end of the measuring life. Until the end of that measuring life, and until the measuring life or the happening of some event. Now the future interest in grantor is reversion. In this case, until the end of the meaningful life, there is no reverter, so we look at that language. And until the end of measuring life, 2A, but if A does not go to law school, then to B. There could be reversion, it could be executory interest, there could be some sort of remainder until the end, where B might have a remainder interest, and here you have none for any sort of future interest in property if you say 4A to A for life.